Right now, if you ask 10 people caught up in the 75-country visa pause what's happening with their case, at least 7 of them will tell you it's still frozen. They're wrong. And the fact that they don't know they're wrong is the actual story here, not the pause itself, but what's happened since, and why almost nobody in your position has been told about it. Somewhere tonight, there's a woman in Lagos who was documentarily qualified at the National Visa Center back in March, who has been checking her case status every single morning since, convinced nothing will move until Washington says so. She's partly right and partly dangerously wrong. And by the end of this, you'll understand exactly why that gap matters for your own case, whether you're the petitioner, the beneficiary, or someone advising a family member from thousands of miles away. Here's what actually happened, stripped of the legal noise. On January 14th, 2026, the State Department announced that starting January 21st, it would indefinitely pause the issuance of immigrant visas, meaning green cards processed through a consulate abroad to nationals of 75 countries. Not visitor visas, not F1 student visas, not H1B, O1, TN, or E3 work visas, just the immigrant visa category, the ones that lead directly to permanent residence. The stated reason was something called public charge, a decades-old legitimate ground of inadmissibility that asks whether an applicant is likely to become primarily dependent on government assistance. It's normally assessed case by case, looking at things like income, age, health, and education. What changed in January is that the government stopped doing it case by case. If you held a passport from one of the 75 listed countries, a list spanning Latin America, the Caribbean, Africa, the Middle East, and parts of Asia and Eastern Europe, your case simply stopped moving toward final issuance, regardless of your individual finances or health or job offer. Picture 3 people living through this at the same time. First, a U.S. citizen in Ohio married to someone from Ghana, with an approved I-130 and a scheduled interview at the embassy in Accra. Second, a software engineer in Bangalore. No, wait, Bangladesh is on the list, not India. A software engineer from Bangladesh with an approved EB-2 petition and a priority date that finally became current after a 6-year wait. Third, a graduate student from Pakistan, finishing a PhD in the U.S., married to another student, filing an I-485 to adjust status without ever leaving the country. All 3 assumed, correctly at the time, that they were stuck. The interview for the Ohio couple still happened. DOS never stopped scheduling interviews or accepting applications. It just stopped issuing the visa afterward, parking the case in something called 221G administrative processing instead. The Bangladeshi engineer's petition kept collecting dust at the consulate, with no denial and no approval, just silence. And here's the detail almost nobody outside immigration law circles picked up on. This wasn't only a consular problem. Domestically, USCIS quietly extended a version of the same slowdown to I-485 green card applications filed inside the United States by nationals of the same 75 countries, which is exactly the lane your PhD student and her spouse were sitting in. Why did this happen at all? Set aside the political framing you've probably heard and focus on the mechanics, because they matter for what comes next. The administration invoked a section of immigration law that gives the president broad authority to suspend entry of any class of foreign nationals deemed detrimental to U.S. interests. Historically, that authority gets used for things like specific security threats from specific regimes. Using it to freeze an entire visa category for 3/4 of the countries on Earth, based on a blanket assumption about public benefits use rather than individual review, was new. And it was legally aggressive enough that a coalition of advocacy groups and affected families filed suit within 2 weeks, on February 2nd, 2026, in federal court in New York, arguing the policy violated both the Administrative Procedure Act, because agencies generally have to give public notice before this kind of sweeping change, and equal protection principles, since the list disproportionately hit non-European, non-white populations. The mistake almost everyone made during those first few months wasn't factual. It was behavioral. Families assumed there was nothing to do but wait, so they stopped responding to requests for updated documents, stopped renewing medical exams that expire, stopped keeping affidavits of support current. Remember, sponsors generally need to show income at roughly 125% of the federal poverty guideline for their household size. And that's a moving number tied to household size and the calendar year, not something you file once and forget. Some people let police certificates or medical exams lapse, thinking, why bother? It's frozen anyway. Others, worse, assume the pause meant their existing approved petition had been canceled, when in fact, DOS explicitly said no immigrant visas already issued were being revoked, and no approved petitions were being terminated. The cases were paused, not killed. That distinction, paused versus dead, is the single most consequential thing people got wrong. Because a paused case that stays document current can move fast the moment the freeze lifts. A stale case has to restart the clock. And the freeze did lift. This is the part almost nobody has caught up on yet. On June 5th, 2026, a federal judge ruled that the pause on immigrant visa and adjustment of status processing for nationals of these 75 countries was unlawful, and ordered the relevant agencies to lift it. The July 2026 visa bulletin cycle reflected that ruling, effectively restoring normal country-by-country processing rather than the blanket freeze. That's not a rumor, that's a documented court order, and it happened roughly 6 weeks before you're watching this. Meanwhile, a second, separate legal effort, a proposed class action seeking additional remedies under different legal theories, was set for filing on July 10th, aimed at making sure people whose cases were refused or shelved during the freeze get a genuine path back into the queue, rather than being told to start over from scratch. So here's your open question answered. The reason this matters more than the freeze itself is that a court order lifting a policy doesn't automatically mean every consulate, every visa officer, and every USCIS field office has caught up in practice. Court rulings restore the legal obligation to process your case normally. They don't hand-deliver a fixed timeline to your specific file. That's the trap right now. People think the ban is over means my visa is coming any day, when what it actually means is the artificial blockage is gone and my case goes back to being evaluated on its own facts, at whatever pace that consulate or field office is currently running. For the Ohio couple, that likely means their 221G case gets re-reviewed, and absent an actual individualized public charge concern, moves toward issuance. For the Bangladeshi engineer, it means the petition that sat untouched should now be adjudicated like any other pending EB2 case in the queue. For the PhD student adjusting status domestically, it means her I-485 goes back into USCIS's normal processing rhythm, rather than the special hold, though normal processing for adjustment cases still commonly runs many months, so patience is still required, just not indefinite, open-ended patience. If you're in any version of this situation, here's what I'd actually tell you to do. Don't wait for a letter to arrive confirming the freeze is over. Go check your case status yourself, this week, whether that's through the National Visa Center portal, the consulate's own system, or your USCIS online account, because the burden has quietly shifted back onto you to keep your file document current. Renew anything that's expired. Medical exams typically run out within roughly 6 months to a year, depending on the civil surgeon's findings. Police certificates and affidavits of support need to reflect current addresses and current income. If your case was refused or placed in prolonged 221G status, specifically because of the country-based pause, rather than an individual finding against you, that's worth flagging to counsel now, while the class action window is active, rather than assuming it will sort itself out.
And if you've simply been sitting quietly, assuming nothing can move, that assumption just became the most expensive thing in your case. If this is where you are right now, I know it doesn't feel simple, and I know the court fixed it doesn't feel like enough when you're the one still checking a portal every morning. But the practical truth is this. The freeze that felt permanent in January was never actually permanent, and the version of you who keeps your documents current and checks your status proactively right now is going to move through this system months faster than the version who waits for someone to tell them it's safe to act. If you want to understand exactly how the 221G administrative processing category works, and why some cases clear it in weeks while others sit for a year, that's exactly what I'm covering next, so stay subscribed for that one.